Please be seated, everybody. Is that feedback?
I am on mute.
There we go. This is case number 2018 CA 5321, Jack Kowalski, et cetera, et al. Versus Johns Hopkins All Children's Hospital. Let's take appearances, starting with the plaintiff.
Go ahead, Tom.
Tom Elliott and Amy Ferrier is on also for the plaintiff, and
Greg Anderson and Nick Whitney will be here in a moment for plaintiff.
And this is Chris Altenburn for Johns Hopkins All Children's Hospital.
And we've got a number of things to do, and I forgot one thing. Yeah, but don't we have this one? Yeah, I'd rather not move that one, if at all possible.
Looks kind of lonely in there, Judge.
That's quite all right. We have a number of things to do today. I'm going to have some announcements. I'm going to give you where I am at with the DV rulings, and then we're going to get to the jury instructions. Now, with announcements, these are announcements. These are not discussion points at this point. So the first thing, listening to Mr. Anderson's comments about the time yesterday, I went back and looked. Certainly the jury has been asking a lot of questions, and I encourage that. But certainly that's taking some time. Now, the sidebar conferences where the lawyers and I are discussing whether questions should be asked, that time hasn't been counting, but certainly in any event, there's been jury questions, and then there has been follow-up based on that. And I've been dividing the jury questions time 50-50. So, one second. Yeah, so to allow the Zoom to be on the public gallery, since I don't have any of the IT people, I'll have to run it from this monitor. So let me move this monitor so I can actually kind of see you when I'm ruling. Move that over here. Let's see if this camera will move far enough. Well, y'all will just have to live with me looking off screen all the time because I can't see it and bring this camera over far enough. So the art of the possible. In any event, going back to the time, certainly there has been some time because of the juror question. So what I'm going to do is I'm going to give each side an additional 4 hours to use as they see fit. That will just be added into the time. Now, I came to that by looking at the amount of time that we've already used with juror questions and kind of anticipating that the jurors are going to continue to have questions. And so that's my approximation of the impact by the juror question. So I will add 4 hours to each side. Now, I'm also going to start trimming our sails a little bit here. By me adding 8 trial hours, we effectively no longer have any wiggle room in our schedule. So there will not, and I have to assume the defense will use all of their time and that the plaintiffs will use all of their time. So unless we've already discussed a day off or there will not be a jury, there will not be any further days off. So that means next week will be 5 days without any days off. The arguments, again, I referenced this yesterday, and I know this is on me because I've allowed it, but I really need the lawyers to confine themselves to have, a single lawyer argue a point. I will certainly listen to it, but I can't have every single lawyer wanting to participate on every single issue because I need, even though that time isn't attributable to either side, we still have to have time to address exhibits and all the other things. So I really am going to start enforcing that, and so I'm just letting the lawyers know so they can be prepared for that. We've already talked about we're going to start Thursday at 8:15 in the morning. This Friday, we will go until 6 p.m. The jury won't go that far, but we will go here to continue to address any outstanding exhibit issues that arise because we really have to start finalizing our exhibits. I'm going to start asking next week to start seeing drafts of the table of contents for exhibits for the jury. I don't know if the plaintiffs are going to be doing that or if the defense is going to be doing that Excel spreadsheet, but I really want to start seeing a draft of that by next week. So those are the announcements. Let me now move over to directed verdict motions and my rulings and where I am with each one. I'm going to go through the directed verdict motions in the order that I put them under advisement. The first 2 motions are for counts 21A and 21B, which is the survivor claim and the wrongful death claim for intentional infliction of emotional distress. Yes, I did receive the plaintiff's memo on this, the defendant's response to that, as well as the plaintiff's reply. I've looked at those memos. And Mr. Altenburn, I have to say that last paragraph of your response memo I thought was very interesting, and your predictions as to appellate relief. But be that as it may, having reviewed everything, I am going to conclude that the plaintiffs did make a prima facie case on both counts 21A and 21B. Therefore, I will deny the motions for directed verdict relating to 21A and 21B. That's counts 21A and 21B. Next, moving on to count 6C as to Jack Kowalski individually. As a reminder, there's a Jack Kowalski individually and then also the Maya Kowalski claim. So this next statement is for the Jack Kowalski individually claim. In Florida law under negligent infliction of emotional distress, there is the physical impact requirement, and there certainly has been a lot of discussion about exceptions to that physical impact requirement. I have previously written, and I didn't write the DIN number, but it's from June 26, 2023, an order granting in part and denying in part summary judgment as to counts 6A and 6C. I did spend some time discussing the propriety of the physical impact requirement. I'm going to quote parts of that order here. Without question, there has been a greater awareness of emotional health and a destigmatization of emotional illness matters over the last couple of decades. Florida's treatment of emotional damages, though, is based on the premise that too many would-be plaintiffs would fake or exaggerate those injuries. Whether that's true or not is besides the point. Florida's common law created this guardrail to help ensure that no false claims are allowed. Perhaps it's time for a higher court to re-examine that common law in this regard. And if there was ever a case to reconsider the physical impact requirement, this would be that case. The physical impact rule is, of course, a judge-made rule, and certainly the legislature could speak on the subject, but in the absence of the legislature speaking on the subject, the judiciary and higher up courts would have the authority to reassess the continued vitality of the physical impact rule. I then went on and discussed a couple of cases from the Florida Supreme Court from 2007, where in two cases released on the same day, and there's 7 justices from the Florida Supreme Court, that generated 11 separate opinions. And trying to reconcile those separate thoughts is pretty challenging. And there was really no clear agreement amongst them other than that the physical impact rule remained. Justice Cantero, who was joined by Justice Wells and Justice Bell, discussed the arbitrary application of the physical impact rule, and that's in the Willis decision, 967 Southern 2nd, 846, and that's Justice Cantero dissenting. And I could not agree more with those 3 justices' views on it. Quote, "As it is, our jurisprudence has created much confusion in the lower courts. During the last decade, no less than 9 times district courts have certified questions to us regarding the rule's application or continued vitality." End quote. Justice Cantero and the other 2 dissenters then offered a solution, which would be to allow emotional distress damages where the plaintiff proved by clear and convincing evidence. I continue to believe that there's a fundamental tenet of law, which is the equal application of the law to all. And in the case of the recovery of emotional damages, it seems to me, and I'm just one lowly circuit judge, I think we fall flat here. Why do we have a rule that has so many exceptions that have no principled contours or understandable or articulable connection to each other? Why is it that one plaintiff is able to recover emotional damages where a similarly situated plaintiff cannot, just because the absence of a manifest physical injury from psychological trauma? And how do we continue to declare exceptions? How does that promote stability of the law or predictability of the law? And therefore, someone above my pay grade, I would humbly suggest, needs to reconsider the physical impact requirement. That being said, Florida law requires a physical impact. Here, with respect to Jack Kowalski, there was a number of items that Jack Kowalski contends were evidence of a physical impact. However, those types, or almost every single one of them, the First District Court of Appeal in the Elliott v. Elliott case 58 Southern 3rd 878 said did not qualify as a physical impact. Certainly, there was a discussion about PTSD as well as dysphagia. However, those in the court's view align with the number of ailments that the First District in the Elliott case said did not qualify for physical impact. That's a long-winded way of saying that the court is going to grant the motion for directed verdict as to Jack Kowalski individually as it relates to count 6C. Now, with respect to count 6C, as it relates to Maya Kowalski, I'm going to continue to reserve, but I'm telling the lawyers that I am inclined to deny this motion based on physical impacts to Maya Kowalski. What I am allowing the lawyers to do is if they wish to have a further written submission to me as to count 6C, as to Maya Kowalski's claim, please get that written submission to me along with any sort of evidence or provisions of the transcript trial testimony that you support or you contend does not or does support this claim. The lawyers can use the email address that I have authorized for the weekend use. You can use that. So I will give you until noon on Sunday. Moving on to count 18, which is the billing fraud count as to Jack Kowalski individually. I'm going to continue to keep it under advisement, and I want a further written statement plus any sort of evidence or passages of trial transcript that you wish to provide me. Here is where I'm at with the billing fraud. I seem to recall, but I'm not 100% sure, that there was testimony that a CRPS diagnostic was more intense than other diagnoses with regard to medical care and attendant medical attention that is necessary. If it is true, does that evidence, and this is a question for the lawyers, does that evidence support a permissible inference that the plaintiff suffered a greater damage due to having a CRPS diagnosis carried in the medical records where the evidence shows, in the light most favorable to the plaintiff, that the defendant did not believe in that diagnosis and did not undertake to treat Maya for CRPS. So I'm going to need evidence on that, and I want any sort of trial passages. Now, I'm throwing out noon on Sunday because I want to keep us moving on. If for whatever reason that becomes impossible due to transcriptions, let me know and we can try to come up with something soon thereafter. Moving on to count 20 as to the fraudulent concealment. This is as to both Jack Kowalski's individual claim and Maya Kowalski's claim on fraudulent concealment of the EEG tape or the tape from the time that Maya Kowalski was in the EEG room. And as a reminder, I had previously indicated that this claim was only for the time period prior to November 17th, 2023, which is the time that the hospital had provided a copy of the tape to the Kowalski's attorney. I am going to grant the motion as it relates to count 20 as to both Jack individually and Maya. There's no evidence of damages in this records or reliance. So I am granting directed verdict as to count 20. Moving on to count 14C, negligent training. I'm going to continue to take this under advisement. I want to wait and see the analysis of the physical impact with respect to the negligent infliction of emotional distress as it relates to Maya Kowalski. So again, if you wish to comment on 14C for negligent training, that memo and any sort of passages would be due on noon on Sunday. Moving on to battery count 5. I'm only gonna, I've already dealt with most of it, so let me get straight to that aspect of the claim for battery relating to the transport of Maya Kowalski to the EEG room and during the time in the EEG room. I need to see evidence of testimony or an exhibit that would show that a battery occurred in that discrete period of time. I know that there is batteries elsewhere, but I just don't recall a specific testimony that it occurred during the EEG room. So I just need to see the passages that the plaintiffs are contending support that there is evidence of that battery. Because I'm continuing to reserve as to that aspect of battery, I will continue to reserve on that claim for punitive damages relating to the EEG room time period. I've previously allowed the punitive damages to proceed with respect to the photo session issue. I did take under advisement the punitive damage issue with respect to the hugs and kisses and pats on the leg. I am going to grant the directed verdict motion for punitive damages as to that portion of the battery. That is the hugs and the kisses, as the court did not find sufficient evidence for a section 768.72 paren 3 finding. Finally, that takes us to false imprisonment. I have previously denied the punitive damage DV motion by the defense on both the EEG room as well as the January 6, 2017 incident. I took under advisement the first week, which is October 7th through October 13th, false imprisonment. Upon reflection, the court is going to deny that motion for punitive damages. There is prima facie evidence of a 768.72 paren 3 with respect to that claim for punitive damages. So that claim for punitive damages for false imprisonment will go to the jury. I believe that now completes the totality of my rulings with respect to everything I took under advisement. So I'm not getting into a discussion about, how and why, but if there's any clarification as to, the memo or the expectation, Mr. Elegant, Mr. Altenburn, now is the time on that.
I'm not sure I got the details of some of your things you want us to address, but if we can get a portion of that from the court reporter as a transcript, that'll solve that problem, I think.
Okay. 16C with Maya, 18, and then count 5, the transport and during the time in the EEG room. And then the court reporter will have the specifics, or you can probably just play it back on YouTube tonight or something.
Okay.
Okay.
I think it was 6C, Your Honor.
Yes, 6C as it relates to Maya Kowalski, negligent infliction of emotional distress.
Yes, and then the battery transport.
Battery transport as well as count 18, the billing fraud.
Yes.
And then technically 14C, the negligent training, but I'm really looking for the physical impact issue with respect to 6C and Maya Kowalski.
Yes, thank you.
But as I said, I'm inclined to deny 6C. I'm just not totally there yet. Okay, let's move on to jury instructions. And I appreciate you all sending. I've got through, a good bit of it. I haven't gotten through it all, but I've gotten through a good bit. So do you want to just start walking through the pages, or I'm looking to you how you want to proceed?
I think going through the pages probably makes sense. I actually have a copy open on my computer if you want to do a share screen on this. I'm not sure.
That's fine.
You're going to have to give me permission, it looks like.
Okay.
By the way, I noticed when I opened this up that the style was still the style that was in existence about a week before trial. And so I altered the style on the document on the screen so it only is the current style.
Okay. Try that, Mr. Altenberg, see if you've got it now.
Yes.
Okay.
Are you seeing what the working copy here?
Yes, and
Yes.
Is this going to be different than what you sent to me yesterday?
I believe it is identical to what I sent you yesterday.
Okay, great.
I guess starting from the top here, the parties all want to use a table of contents.
I agree.
Okay, so I'm going to delete that concern right now. And then,
And Judge, can I ask a clarification? Is this is different from the matrix you're asking for?
Correct. I want a table of contents for the actual jury instruction packet, so that if
Yes.
they want to go to, let's say, the battery instruction, they can look at the first page and they can go to page 18
Right.
or whatever it turns out to be.
Is the matrix something that's going to the jury, or just that we're all going to use to find things?
When you say the matrix, the Excel spreadsheet that is referencing the exhibits, that will go back to the jury. But that's
Okay, I'm sorry. I misunderstood. I thought the Excel spreadsheet was another reference to the instructions. So never mind.
No, that is a table of contents for all of the
Exhibits.
exhibits.
Okay, thank you.
Okay. And where are we going to next, Mr. Altenberg?
well, if we start at the beginning, the first instruction is very close to 407.1. And we have no objections, but I don't know if you want to take a quick look at it.
Yeah, I looked at it and I did not have any problems. If there's nothing of any comments by either of you, and I don't stop you, then I'm generally okay with it.
Okay. And this first one is what I'll call the naming thing that explains who's going to be called things. And it's very close to what we did at the very beginning of the trial. And then we get to the false imprisonment, which the instructions the standard instructions call it intentional restraint, but I think throughout here we've called it false imprisonment. And much of this language is standard, and we have agreed to all of it. The area that is yellow and green here is that there is some interplay with the 39 immunity that could come into play at this spot. And I've done some versions of that. And frankly, whether we need it exactly in this spot, I still think is a little bit up in the air, but hopefully I'll have 39 instructions to you with a little bit of luck by the end of tomorrow. I'm working on the ones relating to visitation right now most, and what my game plan on that is to give you a draft and Mr. Elliott a draft more or less at the same time, because if we're not on the page that you want, it wouldn't make a lot of sense for the two of us to work on something that's not really what you want for the instruction on it. So other than that, I don't think there's any changes.
Going back to the top of page 5 in that green.
Yep.
And was I understanding correctly that green was what the plaintiffs wanted and you had a concern with?
Yes, that's correct.
And my note here was I am fine with an instruction, doesn't have to be those exact words, but the concept of telling the jury that the claims that are being given to them are outside of the Chapter 39 immunity. So I am fine with that concept.
Okay.
Yes, Your Honor. I didn't go back to look at the exact language, but that was basically trying to replicate what you already said in the opening instructions.
Yeah,
Yes.
and I actually wrote something along those lines for the opening instructions, so we can work that out.
And my only other comment there is depending on what else, I mean, if the Chapter 39 were saying if the Chapter 39 constituted, there's immunity for the report or whatever, then this one line would probably be enough. To the extent we're expanding talking about Chapter 39, then we may have some other thoughts on that, but we have to see theirs first. And on timing on that, if it's coming Thursday, I will look at it, but Friday I'm scheduled to be in a federal seminar here presenting at some point, but be there most of the day. So I don't think I'll be able to do much on Friday. But the rest of the team probably can.
Okay. And then going down through here, all of this is essentially right out of the standard instructions, I believe. In blue here, I had just pointed out that we're putting in all these damages with the understanding that at the end of the evidence, we'll discuss whether or not there's really evidence for all of the damages that are in there.
Right, and you've been with trials with me before. I always want to put it the most in because it's always easier to take out than to add.
Yeah. And so we have the standard damages there. Then on battery, this is a special instruction. There is no standard, but we modeled this pretty muchly upon the intentional restraint standard instruction.
Yeah, and can I pause here because I've got a note, and this is probably a little premature because we don't have the verdict form, but were we contemplating, because there's these separate acts of battery, separate acts of false imprisonment. I'm assuming we're going to have a line for each. Yes, no, as to whether each was done. Or were we planning on just doing one master battery and one master false imprisonment?
My intention at the moment would probably be to have a check mark for each one of the batteries and each one of the false imprisonments. And I haven't thought through the damages. Hopefully the damages could be just for the claim and not for each subclaim on this. But because I just ruled with respect to one of the batteries punitive damages claim, I granted one of your DV motions. Certain allegations of battery will not qualify for punitive damages. So, at least for that, you're going to have separate. So perhaps maybe having separate lines, but then I know that opens up the discussion about separate lines of damage for each. So I'm gonna have to try to work through that because the punitives were not written in light of the ruling of the DV. So we'll have to do some adjustment on the punitive damages as to that. Again, the rest of this, the language on what the battery is comes right out of case law. And
my next note was actually on page 12.
Okay.
and I think this is just language that we can deal with later, when it says on either the claim of intentional restraint or the claim of battery, I generally would say or both, after or the claim of battery or both. But again, that presupposes we have to, I think we're probably going to have separate lines for the specific claim of battery.
Right.
Just because ultimately, if certain claims of battery will not support a punitive damage award, I don't want to get reversed by having a general line,
Right.
and then being told you can't tell.
And I may need that for preservation purposes too. I'm not quite certain on that. And then on this page, the matters that I object to are matters that are really predominantly preservation, but the reference to gross negligence, which may vary with each one now, but again, because there was never gross negligence pled in the complaint, these are objections for preservation because you've already indicated that you do intend to use that.
Right, and to be clear, I continued my prior rulings, overruling the defense objection on it. And my intent here is not to cause any waiver, but knowing that I've already made that decision. So, Mr. Altenberg, do you need anything else for a preservation issue from me on that?
I don't believe so, unless Mr. Elegant thinks I do.
I think we had a discussion already. I think the highlighting is probably obviously that won't go to the jury looking like that, but I think that's a good way. And depending on, we may have some highlighting ourselves depending on where we end up, but,
All right. The objection, well, I'll let Mr. Elegant speak for himself on his objection here.
The language above this, Your Honor, is the standard punitive damage right out of the book language. There is no definition of manager in the standard language. I acknowledge that case says what it says, but we're not contending that Ms. Beatty was a manager. I mean, that's not our theory for getting punitive damages here. She, as she said in her deposition testimony that you recite in your order, I mean, she said she was following orders. She's following orders from a risk management. And again, I know it's sometimes a committee, sometimes a department, but she's following orders from higher up above. So I don't think we need this here. I think it might confuse the jury because we're not, again, contending she's a manager.
And it's not needed for Ms. Beatty. It's needed for the second prong as to whether the corporation may be liable for acts by her that are intentional misconduct or gross negligence. And the statutory requirement is in B that officers, directors, or managers knowingly condone, ratified, etc. And the problem is that the testimony is about a specific person in the risk management department whose title, mostly because of the language in the statutes regulating the hospital, is risk manager. But as I explained on Monday, she doesn't really have the level of authority in the hospital that the case law would require for purposes of management. And presuming we put on testimony of that in our case, I think there's going to be an issue as to what a manager is for purposes of punitive damages here.
My
notes,
I apologize, but anything else, Mr. Altenburn?
No.
My notes on this is that I am inclined to give some type of instruction that tells the jury the type of manager, what I always say, how high on the food chain type that the manager has to be. So I'm inclined to give something. I didn't work on the language last night, but conceptually I am inclined to give some type of instruction along the lines that Mr. Altenburn proposed.
Okay. When we get to medical malpractice or medical negligence, it's likely we may need to fine tune the explanation of this breach of the standard of care in this at the end. I'm not certain, but the biggest things that we have discussed yesterday were the Fabry instructions, and my position right now is that I'm not certain whether we're going to actually ask for Fabry instructions at the end, but I'm not prepared to say we aren't. So I'd sort of like to leave this in the working draft just the way it is, and that way when a decision is made later on as to whether we think we have enough evidence to go to the jury, we can worry about the language, because most of this language right now is just straight out of the standard forms. It's not like we wrote new language.
I would like for it to stay in. I'm fine if we just leave it kind of unfinished. And I also want the verdict form to be drafted as if you're asking for a Fabry defendant, because again, it's a lot easier to just pull something out than to go in and try to add it. So
Okay.
I do want to leave it in, and I do want Fabry to be on the verdict form. Now, that's not saying that I think that there is evidence of that would qualify for Fabry, but
And Your Honor, on that, understand that completely. And on that topic, I think one of our positions is that none of the reports say anything about causation, so that's a problem. But beyond that, if there were going to be some sort of Fabry instruction, if the defendants decided they wanted it and you decided they had enough, it would need to be more than this. It would need to go through all the medical malpractice parts that the plaintiff has to prove, not just say, well, we contend they did something wrong too. So it would need to be fleshed out a lot more than this.
right, and that's why I said we could kind of leave it incomplete, maybe inchoate, but I do want there to be a section here for where it would go if we ultimately have it. Plus, I want the verdict form drafted, assuming that there is Fabry defendants.
I understand. And maybe Mr. Altenburn, up in that blue comment, he could add, after causation, say, plaintiffs believe the instruction would need to be fuller or something to that effect.
Okay.
What's next, Mr. Altenburn?
The next line is this jumps into the preliminary issue on apparent agency, and in this front end we added some language that we have agreed on with one exception. Since there's no dispute between the parties that Johns Hopkins All Children's Hospital is legally responsible for the medical negligence of doctors who are its agents or employees or agents. And we had in this, and it's correct law that Johns Hopkins is not legally responsible for medical negligence of doctors who are not employees or agents of Johns Hopkins, but merely have staff privileges that allow them to treat a patient at the hospital. And the plaintiff objects to that.
I don't know what I'm going to do with it, so let's leave it in for now.
Okay.
And Your Honor, our concern, we don't contend that simply having staff privileges makes them by itself an agent, but it's, there's a whole bunch of things that go into apparent agency, and we are concerned that if you tell them, well, if they're not an agent, or the jury may hear it that way. So that's our concern on the wording having more of an impact on the jury than it really should.
Right, and I'm just not prepared to definitively rule on it. I understand the issue.
Right.
And where the insight's coming from.
And I would point out, and Mr. Elegant and I did not discuss this yesterday, but this paragraph, which he sent to me, uses the standard language in the standard instruction on apparent agency. So it has that that Dr. Sally Smith was an apparent agent of Johns Hopkins by word or conduct caused or allowed Beata or Jack Kowalski to believe that Dr. Sally Smith was an agent of and had authority to act for Johns Hopkins All Children's Hospital, and that Beata or Jack relied upon that belief in dealing with Sally Smith as an agent of the hospital. And I just want to make sure, because earlier there had been some indication that they were going to object to the standard language on relied. We haven't discussed that recently.
Well, I think we discussed that in the Rossler case, there's a footnote that says going to the hospital is reliance. I don't think we necessarily want to give that up. But I was there to actually hear Mr. Kowalski testify about his reliance. So there's direct evidence in the record on that. Maybe we can talk about that and get back to it. Let me ask a clarifying question. Is with regard to the reference to staff privileges, is Dr. Smith, Sally Smith, the only one that applies to?
That's correct.
Okay. Well, maybe there's okay.
Yeah.
Maybe that may be something we think about as we're talking about the staff privileges down the road.
Okay. Going on down here. These are all pretty standard right out of the book things on that.
And this is, maybe I'm jumping into the verdict form here, but when we're on the apparent agency, so we're going to have the med mal question and then the apparent agency question.
Well, I'm not sure exactly how it's positioned, but in conjunction with this medical malpractice claim on the verdict form, I'm going to need to have the question of, do you find that she was an apparent agent, or whatever the language is, and a yes or no.
And then when we get to the damages, is there going to be like a instruction, like if you find she is not the apparent agent, then you can't award damages for her conduct, or something along those lines?
Yeah, it's either into damages or you can't find that we're responsible for conduct.
I mean, certainly the jury could find med mal and then also find that she is not the apparent agent of the hospital, and the hospital could still be responsible for a med mal judgment, right?
Right.
Yes.
At the present moment, by the way, if the greater weight of the evidence does not support Maya Kowalski's claim on this issue that Dr. Sally Smith was an apparent agent of the hospital at the time and place of any medical negligence that Maya Kowalski claims Dr. Smith committed, then your verdict on the claim of Maya Kowalski concerning the alleged medical negligence of Johns Hopkins in this case cannot be based on claimed medical negligence by Sally Smith, is how that's handled at the moment.
We may need to add to that for clarification. It could still be based on other personnel or something like that.
Yeah, we'll have to take a look at the following paragraph as well, then, Mr. Elliott. We can take a second look at that. This is just marked in blue because neither one of us have talked to our trial lawyers about which parts of that bracket they want.
That's fine.
That's the same fab rate thing.
This is the fab rate matters there that we.
My note says keep in for now.
Yep.
Yep.
Got it.
And the damages are. Oh, yeah. There's a couple places where we have an aggravation instruction here. It's the standard one, and on your default position of leaving in that which might apply, we're putting it in. But the nature of the aggravation of pre-existing is a little bit odd in this case. So there'll be more discussions about whether that's proven in this case at the end, I'm sure. And then we get to negligent infliction of emotional distress. Well, the one for Jack is gone at this point. So I don't I guess we don't have to worry about that one. The plaintiffs had submitted a combined one, which now won't quite work either. And we had I believe it's here.
Oh, now you're into training. Oops.
Yeah.
Well, I think between us, with your ruling, Your Honor, I think we can rework this so that it's 6C instruction for Maya.
Yeah. I will say that if we do have one on Maya, my biggest confusion is what is the negligence that she viewed, because the jury's not going to be asked to make a finding, I don't think, necessarily on any negligent conduct vis-a-vis Beata Kowalski, because the claims there are only intentional claims.
Well,
So
I'll just wait and see what you all come up with now that I've knocked out Jack's claim.
Okay. And after this, the fraudulent billing, we're still waiting for a resolution of that, but we were not in great difference as to these.
Yeah, perhaps we should kind of skip over the fraudulent billing and wait and see what happens to that one.
And the fraudulent concealment is now out, correct?
Yes.
Okay. Then on the intentional infliction of survival for Beata Kowalski, currently this is very close to the standard instruction. I had wanted to add the estate claims that Johns Hopkins All Children's Hospital acted extremely and outrageously beyond all bounds of decency into that space, as well as in the definition below. It's not standard, but I think emphasizing the narrowness of that at the beginning as well as later on is an important thing to do, and plaintiff's object.
Yeah, Your Honor, it's that exact language appears right below it in the definition, and we don't see the need to emphasize it twice. I mean, I'm sure there's a lot of stuff we'd like to emphasize twice, but if it's in there once, that our view is that's sufficient. The definition is a little further down. Yeah, see, the extreme and outrageous has that.
It's there in that definition.
Yeah.
Okay, so I just want to make sure I'm clear, Mr. Elliott. You just want to remove the phrase "beyond all possible bounds of decency"?
In the blue where it appears in the introductory instruction, because it's already down below.
And what does the standard say?
The standard does not include this, and I ask that it be included despite the fact that it's not in the standard, because I think it's important enough, especially in this case, to be at the front as well, so that they...
And it's
below, yes.
It's part of the extreme and outrageous conduct definition.
It's in the
Yes.
definition, but not in the introduction.
I don't see the need that quickly to have it twice.
The rest of this is standard language. In both of these, but especially in the suicide one, I'm probably going to want to give a little more thought to causation, because the causation instructions in the standard book are all the ones that were written in the 70s, starting with negligence. And this is an unusual intentional tort with kind of layered causation. So I may, in short order here, try to suggest something that's a slight difference from these, now that I know for sure it's going to the jury. And in this one, we had added the language that the engagement in extreme and outrageous conduct in relationship with Beata Kowalski. And I believe that we still maintain that the case law is that it should be sufficiently direct in that fashion. Mr. Elliott has suggested that I think he's okay with this language so long as it also adds Maya Kowalski.
Mr. Elliott?
Yes, Your Honor. I think that's consistent with what you ruled earlier and what we've been briefing.
So you all agree that the words in the relationship with Beata Kowalski or Maya Kowalski, and that solves everyone's problems?
So long as it's with the understanding that I just lost a directed verdict on this issue, yes.
Again, my point is not to have you waive any appellate arguments, Mr. Altenberg.
I understand.
That can be a yellow comment out to the side or whatever.
Whatever. Yes. Well, we're getting it on the track.
And then I think back up above where it's Beata, that'll need to be conformed then.
Yeah, that he and I have basically agreed that if we did this, that would take place. So.
And as a minor housekeeping, I would like to say Beata Kowalski as opposed to just Beata.
Yes.
That was a shorthand.
And there's probably a few places where I still have a short reference to John Hopkins where I'll need to expand them out. These things were left over from before.
Oh, I understand.
This is another.
That's aggravation again.
Yeah, I'm not quite, and this is a little more serious even at this moment in time. I don't honestly remember any testimony that Beata Kowalski had some existing injury that was aggravated by stress in the 90 to 100 days that this was going on at the hospital. And maybe it's in the record, but I don't remember. I remember her going to a doctor or having anything that would be a physical injury arising out of the stress. Whatever the physical injury would need to be at least as extreme as that which is applicable for negligent infliction.
Well, and I think I heard testimony when I was there Monday morning from that doctor that she had stresses and so forth before this happened, and that I interpreted I'm not sure if he used the word aggravation, but I interpreted what he was saying to say that this piled onto it.
That doctor, of course, is someone who never ever saw her ever. Right. He was pining after she was dead. So at any rate, that's the standard that's there, but we'll certainly be arguing about whether it needs to stay there. And these in the suicide section or the wrongful death section,
that would be the same changes.
These rulings should be the same as what you just made in terms of in the relationship with Beata or Maya Kowalski.
That is correct.
And then we get to this language, which is the plaintiff's proposal on what this test should be. You had indicated that you weren't fixed and on these necessarily after you announced them earlier in open court. And I obviously, A, I don't think should be both, and B, I believe, but we can argue more later if necessary, that in this situation, it should not be a substantial factor because it's a but-for causation, and given the interplay with DCF and the like, it should be the substantial factor, so that the substantial factor could operate in concurrence with another factor, but it still has to be the substantial, not just a substantial, as if there could be 6 substantial factors for causing her suicide.
And what I would do, I'd have to go back and look at those cases that I referenced to see how those appellate courts, if they referenced a or the.
Well, and of course, the difficulty is I don't think that any of the prior case law arises in a situation where there's such a competing circumstance as there is in this case with the DCF proceeding coming along at the same time. So one way or the other, I think we need more argument on that. I guess the question is, whether or not, and I will be asking, I'm sure, once more for a definition of irresistible impulse, because the definition I heard, irresistible impulse, I checked, is not in the DSM-5 any place. I could do a word search. It's not there. It's not a psychiatric term. And the definition provided by the expert the other day is pretty far out there as to what it might actually be, and will need a legal definition, in my opinion. So,
And Your Honor, I just took this language from the transcript of your ruling, and as far as substantial factor, all the other things she had going on and the stresses and whatever before, including having a very ill daughter for quite some time, she was still alive until January.
And where are we going next, Mr. Altenberg?
well, the second sentence here, this one right here, is a tad different. I had asked for an instruction that this could only exist if we specifically intended for Beata Kowalski to have committed suicide. You have rejected that argument, and therefore we won't be making this argument. And I see no reason for the court to have something saying that it can't be this when we're not really going to be in a posture where we can even make this argument to the jury.
Your Honor, I took that language out of your ruling, and that really is consistent with that federal Judge Hodges case, because that's one where the person, that was one where the CNN reporter put some story online. She obviously didn't do that intending for the person to kill themselves. She was just doing it to get a story.
My thought is it needs to stay in there, does not have to specifically intend. I think it needs to stay in.
Thank you.
Well, if it does, it means that I'm even more determined that it has to be the substantial factor and not a substantial factor. So the rest of these are straight out of the standards from before. And again, I only marked, well, he asked for this in green, and the only reason that I have any objections, I want to re-examine whether the standard instructions emanating from negligence are accurate for concurring causes in this particular context. I will try to consider that as soon as I can. This is the same aggravation instruction that we've gone through before. And Mr. Elliott, this is the question about lost earnings.
Yeah, I think we need to look at we need to look at that. She was working up to a point when Maya went into the hospital.
But our position, Your Honor, is that in a wrongful death claim of this sort, the injury that caused her death is simultaneous with her death. That it is the act of suicide, so that there can't be a lost earnings claim for this particular claim.
Are we on the survivor claim or on the wrongful death?
This is the wrongful death.
Wrongful death.
Yeah, she could have some lost earnings in the survival claim, but not in this claim, is our position.
Well, assume for the sake of argument that the jury were to deny on the survivor claim, but grant as to the wrongful death claim.
They can't do that because the survival claim only requires emotional stress, and that must exist for the wrongful death. So we've written these so it's that if you don't find on survival, you don't actually respond to this one. and I think we all agree on that.
Okay, well. I think I'm going to need to see the verdict form.
Sure. I just wanted to highlight that. The only question on funeral expenses is who paid them. I believe there is in the record a cremation bill, but I don't know whether the estate paid it or whether her husband paid it. Because it's in twice is the issue. Mortality tables is standard, and all of these, I believe, are standard. And then the objections on Maya's claim are again are a repeat of what you've already ruled on. And so there's really nothing different as far as these concerns than were the concerns on the survival claim for the estate of Beata Kowalski. These are standard instructions. The question is whether there's going to be any proof of these as it relates to this claim or not. I think we could decide that at the end of the evidence.
Okay.
Beyond those, then everything here is pretty much verbatim out of the standards.
I think we had one thing, but didn't we resolve it?
Yes, we resolved it. And I don't remember that it was all that important if we can figure out what it was. It was only about 2 words that we changed in here, and we both agreed they should be changed, so I don't remember what it was.
Well, if you both agree, I'm most likely going to go along.
All right. And I believe that's the whole 9 yards at the moment.
Well, I appreciate very much you all working so well together on this. I know you're still waiting on a couple of rulings from me. My hope and desire is if I can get those memos on Sunday, maybe on Monday or Tuesday, I can make the final rulings on those last few directed verdict motions so that you've got, more definitiveness as to where I'm at.
Okay.
On those claims. What do you want or need from me, Mr. Altenberg and Mr. Elliott, on jury instructions on a going forward basis?
I think nothing right now that I can think of. I'm assuming Mr. Altenburn will revise these and with your guidance today, and we'll look at that and can send them back to you, or can wait until you have the further rulings and then we revise them some more if needed.
I mean, and the only other thing is I know the jury wants and you want, and at least the defense wants, some instruction on the visitation orders. It doesn't wait till the end because it is important to be presented during our case. And I'll try to, as I say, get what I'd like to do first is a rough draft of what I think it would look like in a fashion that may be the way to do it without putting in all of the orders. And, if the concept is something that looks like it's acceptable to you, then Mr. Elliott and I can try to refine it down to what we agree on and what maybe we disagree on. But
obviously our trial teams will need to be involved in that. And I think one thing, I'm sure you're already contemplating this, but that they would have date parameters on each one.
Oh, yes. So that the whole purpose of this is to try to lay out
right.
What was true from beginning to end and what changed here
what
and
changed.
What there,
yes. Because
the orders themselves sometimes look like things are changed, and then you compare the orders and it's just a duplication of language from an earlier order. So I think I can do this in a fashion that is simpler than all the orders, although it may not still be a short sheet description. We'll see.
I appreciate that. I know we don't have the defense trial team, so I don't want to get too deep into anything, but from a timing perspective, I just, for purposes of figuring out what we're going to do, I'm just assuming that the defense is going to use all the time. I am not sure that you all are going to be able to rest by Friday the 27th.
I believe our own internal thoughts have been that it's closer to Halloween that things would wrap up.
And as a reminder, November 2nd and 3rd are not jury days. So that you've got Thursday and Friday of this week, you get 5 days next week. Then we'd have 3 days that following week. And what I really would hope beyond hope is that no matter what, we can be finished with all evidence and testimony, including any rebuttal case, by November 1st. And the reason why I say that is I think we could do, if that occurs on November 1st, we could do jury instructions and closing arguments on November 6th, and then we can start letting the jury deliberate on the 7th. And that would give them the 7th and the 8th, and then obviously the 9th. But if the jury then comes back with any finding on punitive damages, we then have to have a little bit more, and then another deliberation. And Friday the 10th is a court holiday.
Right.
And just to add what else is going on, the second DCA will be sitting in the courthouse. They're going to use the county commission chamber on Thursday, November 9th. So we'll have several judges from the second DCA here on November 9th.
Okay.
But I mean, I really, I guess the takeaway from all of this is we need all evidence, all testimony to be finished by November 1st. And that includes rebuttal case.
I believe my trial team has been assuming that would probably be the goal, so that should not be a surprise.
I know, but I just gave everybody 4 more hours.
4 hours, yes, you did.
Which effectively is almost 2 trial days. So I'm not saying everyone has to use all their time, but I just, we're like I said, we're starting to be a little bit behind, and I'm having to trim the sails a little bit.
All right, thank you, Your Honor.
Yep.
Anything else, Mr. Altenburn or Mr. Elegant?
Not that I can think of.
No, I don't believe so.
And then so I will see whoever's going to be here in person tomorrow at 8:15.
Okay.
And I assume, Mr. Altenburn, you're staying in Tampa now for the majority?
I'm going to be in Tampa at 8:15 tomorrow morning. I'll tell you that. So,
As will I hope.
Well, you said you had a CLE that you're running on Friday?
Not running. I'm a participant, but I thought it would be respectful to go listen to the federal judges before I spoke. So I'm going to try to make most of it.
I understand. Okay. Anything else before we call it a day?
No, you're on.
Thank you.
Thank you all very much. We'll be in recess.